Madam Secretary.
Engrossed Senate Bill 2366, a bill for an act to amend and reenact sections 38 and 54 of the Century Code relating to regulation of the oil industry by the Industrial Commission and promotion of the oil industry by the Department of Commerce. The fiscal note that is attached does not indicate what the impact would be.
Senator Armstrong.
Mr. President, Senate Bill 2366 comes from the Energy and Natural Resource Committee with a 5-2 do not pass recommendation. This legislation would remove the promotion of oil and gas development from the Industrial Commission and move it into the Department of Commerce. The policy to promote responsible development in oil and gas resources has existed in the Industrial Commission since it was adopted in 1953. The promotion of responsible development and utilization of natural resources is essential for the protection of correlative rights of mineral owners and fosters the ideas of secondary recovery, organized spacing, adaptations to emerging technology, and prevention of waste. We heard testimony in committee on both sides of this issue. The committee was persuaded that this legislation is not in the best interest of the state of North Dakota. There are many parts to the Industrial Commission that would be adversely affected by this legislation. The Geological Survey Division testified in opposition. Many of their programs would be negatively affected. The programs such as the Oil and Gas Research Program deals with promotion and with environmental issues, best practices, development of natural resources, of the development of the natural resources in all aspects. In short, the Oil and Gas Research Program would like to stay under the Industrial Commission tent, as they have a varied job description. If they would move to the Commerce, much of their mission would be lost, and they would be more focused on promotional activities. These programs do great work, and the committee agreed that they should remain where they currently reside. We heard testimony from the Executive Director of the Interstate Oil and Compact Commission, of which North Dakota has been a long-standing member. In fact, 3 North Dakota governors have served as chairman of this commission. He testified that we would be the only member of the commission considering bifurcating a portion of their oil and gas duties to an unrelated agency. He cautioned us to remember that we are always competing with other states for drilling dollars. Finally, the question was asked as to why this bill singles out oil and gas development and promotion and regulation. Many other North Dakota agencies have dual roles in promotion and regulation. The Game and Fish both promotes hunting and fishing and regulates those activities. The Department of Agriculture promotes farming and ranching and also runs 7 regulatory programs. The State Board of Higher Education promotes college and regulates the same. Mr. Chairman, our Department of Minerals Resources is a fine agency. They have a difficult job. They wear many hats and they do these jobs with diligence and dignity. Your Natural Resource Committee supports their current mission and their current members, and we ask for a do not pass on 2366.
Senator Triplett.
Mr. President, may we be on the 8th order for purposes of an amendment?
We may.
Find it back. Mr. President, I would move Amendment 15.0993.02003.
There's a motion and a second to adopt Amendment 15.0993.02003. Senate will be on the 6th order of business for purpose of amendment. Is there discussion?
Oh.
Senator Triplett.
Thank you, Mr. Chairman. Mr. President. As the members will be able to see from the amendment, it is a hog house amendment to the bill and much simplifies the bill. In fact, it is so simple that it is really the deletion of one word and replacing it with one other word. I bring this hog house amendment because I want to focus on what I consider the real issue and not the extraneous issues which ended up being discussed mostly in committee. So the first sentence of our declaration of policy would then say, it is hereby declared to be in the public interest to foster, to encourage, and to regulate the development, production, and utilization of natural resources of oil and gas in this state. And it goes on, and you can read the rest of it for yourselves. As the carrier of the bill indicated, this language has been in statute since 1953, shortly after oil was first discovered in North Dakota. We learned in the hearing from the executive director of the Interstate Compact that the language came from a model law, which was adopted in nearly identical form in many states. And as I indicated in testimony in the committee, I think it probably was a reasonable statement of intent in 1953 when North Dakota was newly in the business of competing for oil development resources from oil companies who were obviously by then active in other states but not in ours. All these many years later, I think it's time that we should change slightly the focus. And maybe the bill was a bit of an overreach in the beginning when it talked about moving particular things to commerce, and that's why I'm bringing this this bill. I will just point out, as I did in committee, that the idea was not original to me. I actually first thought of it when it was presented by the governor of our state in his 2011 budget address, in which he suggested setting up a division of energy within the Department of Commerce. That did not come to pass, but we have, since that time, put, and even before then, I think, put some significant resources toward the promotion of energy development into our Commerce Department. I think every member is likely to be aware of the fact that the Empower Commission, which seeks recommendations from all members of industry, works out of the Commerce Department, and the Commerce Department is the chair of that commission. We also, in the last legislative session, put a significant amount of money into a study that was managed through the Commerce Department for consideration of value-added projects for natural gas. And so it just seemed to me that we had essentially kind of already made a subtle decision to start moving some of those promotion activities, and that it wouldn't hurt just to clarify that. But since there was no support in that in the committee, support for that, I think that I just wanted to back up and get to the heart of why I brought this bill. And that, Mr. President, is the notion that it is really a conflict of interest, I think, for the head of our Division of Mineral Resources, both to be expected, both to promote and to regulate oil. And I said it in the committee, and I'm going to say it here again. This bill is not intended to be an indictment of the current occupant of that office. It is not intended to be an indictment of the current occupants of the Industrial Commission chairs. It is rather to say that we, as members of this legislative body, do have the right and the responsibility to set overall policy for our agencies. And I think that it is time, with all that has passed in the last several years, that we just be clear that our directive to the Industrial Commission is that we want them to focus on regulation, and that if there is to be promotion, it can be done elsewhere, and we maybe don't have to specify it in this bill, but that regulation needs to be at the heart of what the Division of Oil and Gas does. And I do want to take just a minute to respond to the suggestion that other agencies have similar co-responsibilities. That certainly is true, but I think the distinction here, for me personally, is the potential for harm, and I do mean serious harm, life and death, to people from mistakes that might be made in the misregulation or the lack of regulation in oil and gas. I mean, certainly when you look at game and fish, for example, promoting the production of wildlife really is not likely to cause any serious amount of harm, while the same agency is also regulating the hunting of that wildlife. The two kind of go together hand in glove. So I think it's a little bit of a red herring to compare this to other agencies or other situations, because we really are talking about life and death issues in oil. And I used one example in the committee, and I'm going to use the same example here. And I would appreciate, Mr. President, if you would just give me a 1-minute warning here in case I'm in danger of going over my time.
You're at 4 minutes and 39 seconds at this moment.
Okay, thank you. the example that I want to share, and the reason that I chose to bring this bill in the first place, is the issue of rail safety. And I think you all know the history. I'm going to review it very briefly. Terrible, terrible accident in Canada, causing many lives lost, an enormous amount of destruction. Other derailments around the country, one of which occurred within a half mile of one of our small towns. No injuries, thankfully, but it really focused the attention of the continent, I would say, on this issue of rail safety. And there have been significant improvements and changes made at the national level regarding rail safety. But I think this is a responsibility that I take personally, and I do not want it on my head if there is another accident of that sort. And so I'm just going to go through and tell you what I have perceived happened and why I think it illustrates the issue of a conflict. After the Canadian incident, but before the Castleton incident, the director of the Division of Oil and Gas was quoted in the newspapers. I was not present, but quoted in the newspapers at one of our hearings, suggesting that he was going to be working with industry on a white paper to prove that our oil was not more volatile than other oil. As soon as the accident in Castleton happened, the idea for that disappeared. Then, at some point, the Industrial Commission decided to hold hearings, and I attended those hearings and I testified. And before I did that, I studied all of the studies that had come out, and it was clear to me that there were discrepancies in the federal government studies versus the study that was commissioned separately by the industry lobbying group. And so I suggested to the Industrial Commission at that hearing that they needed to really understand what the methodologies of both of those studies were, such that they could then make a logical and rational decision on what was needed going forward. That it wasn't good enough just to flip a coin and decide one or the other was better. I don't think that happened, and what really caught my attention was that 2 days after that hearing, I made a presentation at our industry's primary lobbying and promotion group as part of a legislative panel discussion. And while I was waiting my turn to speak, I heard the director of the oil and gas provide an overview of the hearings, and he used the word backstop. He told the assembled group of industry people that whatever the decision was that he recommended for the conditioning of oil, that it would be nothing more than backstopping their current behavior. And I will just say that at that point, I lost faith. I lost faith that that regulatory process was working. And then I went and listened in when he presented to the Industrial Commission. And our Industrial Commission, as you know, is not made up of scientists or experts in the field, and so they rely heavily on their staff for recommendations. And at that point, he told them that what he was recommending would make the Bakken oil as safe as gasoline. As safe as gasoline. Now, there's not a whole lot of gasoline that is transported by rail in this country, and I don't think that making our oil as safe as gasoline is good enough. And I'm not sure how much all of you know about common carriers, but our common carriers, including the railroads, don't get to choose what they accept and don't accept. Because they have a monopoly granted by the federal government, they have to take what is offered to them, and they rely on the federal government to set the rules for safe transport, for how the materials that are put into those train cars have to be labeled in order to be transported safely across this continent. And in order for that to happen, the shippers of those products have to be honest and upfront about what is being put into them so that the rules can be followed appropriately. And I don't think we know yet whether our Bakken oil can be transported safely. And I studied this as much as I could, Mr. President, and I read as much as I could, and I participated in the process, and in the end, it felt to me like there was a conflict of interest on this very, very important topic about promoting our oil versus regulating the industry. And I want to have confidence, and I want our people to have confidence in our regulators. And I think that it is imperative that we step up and make sure that our industry is being regulated, and that if there is promotion to be done, it be done by someone else. Not saying who at this point. I would urge the group to pass the amendment so that we can then pass the bill.
Senator Armstrong.
Well, Mr. President, I would ask that you reject this amendment. And mechanically speaking, I'm not sure it changes one thing. Well, I know it doesn't change one thing in the way the Industrial Commission regulates the oil and gas industry. And I think that the Oil and Gas or the Natural Resources Division, or Department of Mineral Resources, I've got it now, Mr. President, they do a great job. They have a tough job. They regulate, and I think the big misconception here is how the word promote is used. The word promote is to foster and encourage new and emerging technology and the spacing, CO2 reinjection, things that they do in the Department of Mineral Resource. And this bill is all about perception and not one bit about policy. The amendment is all about perception and not one bit about policy. And I'd ask that we reject it and then reject the bill.
Is there any further discussion? Hearing none, the question will be on the proposed amendment to Senate Bill 2366. As many as in favor say aye. Aye. Opposed say nay. Nay. The nays have it. The amendment has failed. Senate will return to the 11th order of business and have under consideration Senate Bill 2366. Is there further discussion? Hearing none, the question will be on the final passage of Senate Bill 2366. The Secretary open the key and every member record their vote. Has every member voted? Does any member wish to change his or her vote? Secretary, close the key and take the tally. Tally reveals 15 senators voting yea, 32 voting nay. Senate Bill 2366 has failed. Next bill under consideration.